Good morning. Welcome to the Utah Court of Appeals. We're here for argument in case 20220033, State versus Sebastian. And if I could have counsel make their appearances for the record, please.
Axel Trumbo on behalf of Santiago Sebastian.
All right, good morning.
Tara Peterson on behalf of the state of Utah.
All right, good morning. Welcome to you both. I'm Judge Oliver. I'm chairing our argument this morning, and to my right is Judge Christensen Forster, and to my left is Judge Luthi. I see that there are 12 minutes on the clock, so I assume you've reserved 3 minutes for a rebuttal. Is that correct?
Yes.
All right. Before we begin argument, do we have any questions from either side? Okay, well, in that case, Mr. Trumbo, we'll hear from you first.
Your Honors, may it please the Court. This is a sad and disturbing case involving three convictions of rape of a child between a father and a daughter. But those convictions entered only after an unfair trial where my client did not receive effective assistance of counsel. The state's primary argument on appeal, as I understand it, is that there couldn't have been prejudice from the noted deficiencies, because in their view, the testimony of the daughter and the interrogation evidence was so open and shut. But Your Honors, that's simply not true. The state had a very difficult case to prove with limited and questionable evidence. In thinking about prejudice, I think it's helpful to remember that the state insisted on charging only rape of a child and no lesser sexual offenses, and objected to jury instruction with lesser offenses. And so excuse the explicitness of this argument, but that meant that they needed to, on three specific occasions, to prove that Sebastian specifically touched his daughter's vagina with his penis on those three instances.
Don't we have a distinction, though, between the three counts here, because he has admitted in his testimony before the jury about the contact, at least on that one occasion.
On the third occasion, he does. He says it's accidental, so there's the mens rea element. So his testimony versus hers, it's still a credibility argument.
Right, but the evidence is meaningfully different with respect to that count because we do have his admissions.
Correct.
Okay.
Now,
I guess I have a follow-up on that. If we were to decide that the evidence was meaningfully different enough that the prejudice, the prejudice argument that the state is making is availing for the April 16th incident, but maybe not for the other two, we would have the option, would we not, of affirming the April 16th conviction and reversing and remanding on the other two, where we wouldn't be tied to an all or nothing affirmance versus reversal, would we?
I tried to find authoritative instructions on this situation. I didn't find anything authoritative. I did see cases in other jurisdictions where there was a partial remand, but those were cases where things were compartmentalized pretty clearly. For example, those were cases where the jury instruction on a particular offense was incorrect. And so the court said, well, stating the jury instruction incorrectly for that offense couldn't have affected the convictions on these other offenses. And so they did do that partial remand. Here we have prosecutorial misconduct and evidence, improper evidence that strengthened improperly the victim's credibility generally, that attacked the character or inflamed the passions of the jury against the defendant generally. So I do think this is a situation where there's going to be at least some spillover into that third offense.
And I think that's what you've just said goes more to should it be open and shut and no prejudice in the one count versus the other two. But I don't hear you saying that procedurally we're barred from doing that.
I haven't seen anything barring the court from procedurally doing that.
This is sort of a general question, but does reversal of all of the counts require us to grant your 23B motion? Or can we do that without a remand?
We do think that we show deficient performance and prejudice just on the appellate record, which would mean that you shouldn't grant the 23B motion if all the evidence you need is already in the record. That's the first element. But if we can't show that on one or more of these convictions, then if we have convinced the court that the remand is appropriate, then the court should remand to supplement the record. Going back to the issue of the strength or weakness of the state's case, we have a situation where, again, they need to prove a specific crime, which is very difficult to prove when the daughter's testimony at trial even is that she was asleep for 2 of the 3 occurrences. And if we are able to supplement the CJC interview, then we have a statement that she was asleep during anything that would have happened during that time period, and that her father simply touched her while she was asleep. Another odd element to her testimony is that she says she locked her door before these incidents, and that somehow, in a way that was unexplained at trial, that her father appeared in her room to harm her. That's certainly something that can raise reasonable doubt in a jury's mind as to the credibility of her version of events. Moving to the interrogation testimony, there's really 2 layers of problems there. First was the fact that this was conducted in Spanish without an interpreter, the interrogation itself, when neither participant in the interrogation had a sufficiently strong grasp of the language. And that's evidence in the appellate record itself. For example, Officer Jensen, the interrogator, we have a moment in the trial where it's pointed out that he had problems finding the word for penis and had to be helped along by the defendant. That's certainly concerning when the subject matter of the interrogation is an allegation of a sex crime. And so there is evidence in the record of his difficulty with the language, that he learned Spanish as an adult in Texas on a church mission. And then the defendant himself says at trial that he doesn't speak Spanish very well, that he grew up in Guatemala speaking Chuch, a Native American language that is very different from Spanish, and that he actually learned.
All of this was in front of the jury, though.
Again, suggesting that this is not open and shut, clear-cut evidence that means there cannot be prejudice. And so the point I'm trying to make here is that you should carefully look at all of the deficient performances and consider whether that moves the needle sufficiently to create a reasonable probability.
But doesn't that cut against you, though, if that evidence is sufficiently before the jury for them to understand, question that there was reliability to the interrogation because of the language capabilities of the 2 people who participated? I mean, doesn't that cut against you? Because that's really the point you're making, is that it was unfair and it shouldn't have been credited, right? But those arguments were made to the jury, and they nonetheless reached a conviction.
That only cuts against me on this slightly, on the specific issue of whether it was deficient to not require a better interpretation or translation of that interrogation. So perhaps it was already sufficiently discredited in front of the jury. But it's absolutely to our benefit that on this argument that the interrogation was effectively challenged and undermined, because it shows that this was a difficult case for the state to prove. This wasn't an open and shut case, and so prosecutorial misconduct where the prosecutor fabricates evidence that was never put on trial, that can very much sway something from the case from reasonable doubt to conviction.
And this is on the DNA piece, right, on the sperm fraction?
There's
That you're referencing when you say making up evidence.
right, and I don't mean to say it was on purpose, but the prosecutor said we found sperm when that wasn't the evidence, but that's not the only thing.
I
He
don't
also
think that's what the prosecutor actually said. The prosecutor actually said a sperm fraction found on a swab from inside of the thighs and buttocks produced a DNA profile which was consistent with the defendant to a degree of certainty.
Right. So finding a sperm fraction on the swab taken from the victim, that is telling the jury there is a sperm fraction on this swab that we found. That is not what the term sperm fraction meant in the report. That's not what Mr. Polson testified to.
But I think what the prosecutor highlighted was that Mr. Sebastian's DNA was found on the victim, and that you acknowledge that certainly, I mean, these two people lived together. The fact that DNA was found on the victim is uncontested, right? I mean, basically that it could be found on the victim could be uncontested.
Correct.
But I don't think, I mean, I guess maybe you can point me to exactly in the closing argument, other than that one instance where sperm fraction was used, that the prosecutor suggested that the substance that was found on the victim was sperm rather than DNA. And why when the DNA was found on her, that was inconsistent or went against the defense that defense counsel acknowledged that there was at least one count here that the evidence proved, the April 16th count.
Right. So there are a couple things there. First, there are at least two moments in time where he, that I recall in the record, one instance was, I think, around page 731, where he says, not that we found DNA on the swab, but we found a sperm fraction on this swab from the victim. And that's the language he uses when you pair that to the fact that they're dealing with a situation where the victim is waking up and making conclusions about what had happened to her. They need to prove, look, we need to show that his penis was involved in this occurrence. How do we prove that? And that's when they bring in this testimony of wetness that she felt.
But they also bring in his testimony that, yes, I acknowledged penetrating her by however far his fingers showed, but that he showed with his fingers how far he penetrated her. And I guess this moves away from exactly what's being addressed, but to the harmlessness question. If he is the one acknowledging, I penetrated her, how is the fact that there was sperm on her thigh or wherever, how is that what tips the scale in this case?
So it helps to tip the scale because first they're trying to prove in the jury's mind, look, for the April 16th incident, when she testifies about wetness, we're dealing with an ejaculation. And we found a sperm fraction, and so they're helping the jury connect the dots there. Then he inappropriately says, again, this is another fabrication of evidence that was never in the record. She felt on April 13th the very same wetness that she knew only too well. Well, that's testifying about wetness, not just on the April 16th incident, which is the only time that she testified to that, That's April 13th, and that's previous to April 13th as well. And so they're connecting the dot for the jury and saying, look, there's evidence here of ejaculations on several occasions. And we have physical evidence from the very most recent wetness incident that we found on a swab a sperm fraction. This was very prejudicial to the defense.
And it seems as though you're suggesting that the prosecution had the obligation not to use the term of art, but to shift on its own accord into colloquial language, and not that it would be permissible for the prosecution to put the onus on the defense counsel to clarify for the jury that sperm fraction is a term of art. We don't know if that means there was sperm, only that there was DNA. So it seems like we ought to be looking at this, if at all, in ineffective assistance context and not a problem with what the prosecution did.
Right, and we do make the point that that the defense didn't do proper investigation into this report to know what was going on, and that he misunderstood this term as well. But if the state is going to use the very potentially inflammatory term of sperm fraction, they better use it correctly, and they did not. He said they found a sperm fraction on the swab. That is factually incorrect. A sperm fraction only appears.
Is derivative from the swab. Is that what you're saying?
They take the DNA from the swab, they amplify it, then they they fractionalize it into two fractions, which is always denominated sperm fraction and non-sperm fraction or epithelial fraction. It's in the lab that they create the sperm fraction. They don't find a sperm fraction on the swab. And so he misused the term in a way that's very suggestive of finding semen or sperm. Your Honor,
And so your argument is not necessarily prosecutorial misconduct, it's ineffective assistance of counsel for failure to both investigate and maybe get their own expert to be able to respond when this misstatement was
right.
made.
It's the failure to investigate any of the expert testimony at all. And then also, when the statement is made in closing arguments, failure to object to very prejudicial prosecutorial misconduct and to correct the record, have an instruction to the jury clarifying this point.
We have lots of questions.
Yeah. You don't
Okay,
need to.
sure. I could stay here as long as you'd like me to.
Continue, please.
Could I go to the 23B?
That's where I was going to go to, but you go first.
This is my overarching concern with your 23B motion. That in Griffin, our Supreme Court said that when a defendant alleges that counsel failed to investigate or call a witness, and I'm thinking here now of, let's get in a witness who can transcribe the Spanish language interview and get us an accurate Spanish language translation. When a defendant alleges that counsel failed to investigate or call a witness, the defendant must, at the very least, identify the witness. And then in Griffin, the court applies that and says Mr. Griffin wants to go back and on remand talk to any of several people who said they were eyewitnesses, but Mr. Griffin didn't name any of those people who were potential eyewitnesses. And the court says allegations that counsel did not follow up with these additional unnamed witnesses fail because they are too speculative. Mr. Griffin must at least be able to identify the potential witnesses. Mm. It seems that if we follow Griffin, we would need to send, at least on the Spanish language translation, send it back on 23B for you to testify and create the accurate transcription, because you've not identified anyone else that could do that.
Well, I see Your Honor's point, but I think this is a very different situation where both sides have this this interrogation interview. All that needs to happen is that it be transcribed, translated in a way that ideally both sides can stipulate to the way in which agree to an official transcription. Really, there's no doubt that any court interpreter can accomplish this. Even the interpreter that we had at trial, Ms. Page, her issue was, she was saying, in my 23 years of experience, they always let me do a transcription in this type of a situation. And she actually was able to accomplish a partial transcription in a pretrial hearing on the question of Miranda. So we know she can accomplish that. I don't think there's any real question that we're simply speculating that someone is going to be able to effectively transcribe this. That's not the issue here. Like it would be in a fact witness scenario where we're saying we think that some unidentified person can bring helpful testimony here. Then you at the very least need to be able to identify who you're talking about. For example, if we identify...
The reason why I think it's still problematic is that there's an overlap between the person who will do the transcription has not been identified, but also whether that would make a difference. Really, we really need to be shown that there's a difference between what the jury was told as the interview was played and what the jury would have known of that interview had it had an accurate or complete transcription. And we need an indication that it would make a difference. And so all we have in that way is you telling us, well, here's what the interpreter said live, doing a live translation, and here's what would have been given in a transcription with ample time to do it.
Right.
And we don't know if another Spanish language interpreter would give us the same contrast that you've purported to give us. That you've really set yourself up as the witness. Yeah, that's,
Sure.
How do we get around this? Or are you willing to be the witness?
It may be the case, certainly on remand, that I'm not counsel on remand, and maybe we're stuck with something like that, and I certainly am capable of doing that. But I think the point that our burden on the remand is to say, look, we're not speculating here. The state has not taken issue with the affidavit talking about the difference between those. They're just saying they don't think it makes enough of a difference. And certainly that's not the only basis that we're asking for a 23B remand.
Sure.
But
So, I mean, I guess you have to, I see your point, and tell me if I'm understanding you correctly, that to get a remand for under Rule 23B for entry of findings of fact necessary for the appellate court's determination of a claim of ineffective assistance, the motion will be available only upon a non-speculative allegation of fact. So the allegation of fact that you don't believe is in the record is that the transcription that was provided to the jury was inaccurate.
I think we're saying more than that, because if all we were saying there is that's already in the record. That's already in the appellate record. So we're saying more. We're saying here's some key portions of the interrogation, and this is how it would have been transcribed had it been transcribed more fully and accurately. And look at how it can make a difference between, for example, clear moments where he's being asked, did you penetrate? Talking about these 2 or 3 instances, no. And so the point, I guess the factual point we're making is, allegation we're making that's not speculative based on the affidavit, is that a correct transcription could help in showing, could have made a difference to the jury and could help in showing ineffective assistance of counsel.
Can I stay on that 23B claim and just ask you to show me in your table of testimony of as it was interpreted in real time versus your evidence of what it would show if transcribed? I don't see, I'm not sure that I see a meaningful difference, that in both versions, he says, for example, I didn't rape my daughter. In both versions, he acknowledges penetration in the April 16 incident. I don't read either version as him acknowledging penetration in all three instances. And so I'm not sure that, given what you've told us the differences may be, that I see there being prejudice in the way it was originally interpreted.
Well, if that's the court's conclusion, then you wouldn't remand in order to get a transcription. You would remand to get a translation of the CJC interview, of the mother's interview, which we claim are contradicting their trial testimony.
Well,
that should
sure,
have been used.
but I want, if you're conceding that that's the way we should view it, that's very helpful. But if you're contending that, no, that it's meaningfully different between his interview, between how it was interpreted in real time and how a transcription would read, if you could point me to those meaningful differences, that would be helpful.
Well, so a premise of Your Honor's question was that you think that at trial, there was also
some ambiguity, at least, as to whether there was penetration on the April 6th and April 13th.
right. So if you're already there with the trial transcript, then there's not much to accomplish with the remand. But if you are thinking for some reason, I think there is a clear admission as it was interpreted at trial, if you're thinking that way, then I'd point you to, for example, page 16 of my affidavit, where did you penetrate your daughter? No. And
I certainly think that that's clear, no, but the question is, what was he talking about there? No.
right.
And I think there's some ambiguity there, but the follow-up is, but she said that you did, and it seems like there was understanding, or at least the same amount of understanding in both versions that, no, but now we're talking about this
Right.
last incident.
To be clear, we're not saying that if transcribed, there's going to be no ambiguity in this interrogation. It was very ambiguous based on the fact that they're both speaking essentially a second language to each other and are struggling throughout the interrogation. So really, I mean, and that's, I'd say the most important reason for a remand would be the CJC interview, would be the mother's interview, and would be other elements like the full physical examination report and the cross-examination fodder that was in there that wasn't used to really limit or even exclude expert testimony.
And I guess as moving to the examination report, I think I understand on the report itself perhaps, but in addition to being able to identify the witness, because I think you've identified, we'd like to get nurse on the stand and have her testify. But we don't have an affidavit from nurse saying what she would testify to, or an affidavit from anyone saying, I spoke with nurse, and she said this is what she would testify to.
Right.
We have arguably speculation that if we could get nurse on the stand, we think she might say this, based on what we're seeing in her report. But without, it seems like that kind of speculation is what we'd call a fishing expedition and isn't allowed. And that the question would be closer if we had in an affidavit, we tried to speak with nurse. She refused to speak to us. So all we can do is do our best to infer from her report what she might say.
Yeah.
Then I think we've got a closer question, but we don't even have an attempt to speak with the nurse.
Yeah, so there's really two levels of what we're looking for there. First is the report itself, the full report, which is not in the record currently. And we'd be able to show the court more fully how statements she made at trial are not in the report. Findings like consistent with penetration or recency of the injury, that's not in the report. And things along those lines. So just the report itself would be very helpful if the court doesn't find ineffective assistance absent the report. But then, we do rely on the concept in Griffin that we don't have subpoena power at this point. This was an adverse witness, an examination that we don't have for you an affidavit saying these are the efforts we made to contact her. Your Honor, I don't want to keep going with my own arguments since my time is up. Is there any other
Let me
question?
see,
for
do
me?
we have further questions at this time? All right, not seeing any, we'll conclude the opening part of your argument and we'll give you your full rebuttal because we certainly are the ones who kept you past your time.
Thank you.
All right, Ms. Peterson, we'll hear from the state.
Good morning, Your Honors. Tara Peterson on behalf of the state. The easiest way through this case, both the direct claims and the 23B, is that there's no prejudice here. All of defendant's claims, including all of those in his 23B motion, fail because he cannot prove prejudice. There is overwhelming evidence of the defendant's guilt, and there is no probability, let alone a reasonable one, that any jury would have found the defendant not guilty based on any of these claims.
Not guilty of at least one count,
Well,
or not guilty of all three counts?
not guilty of all three.
Okay.
And just responding to the court's question, this court could remand just on two if it wanted to, but there's no reason for the court to do that. There should be no remand here. The court should affirm on all three because there was overwhelming evidence of all three counts here. And I'll just briefly go through some of that. First, the defendant at trial admitted his guilt. He testified both on direct and on cross-examination that he touched Alice's vagina with his penis, and that is enough to prove rape of a child.
Did he admit that as to more than one incident?
Yes, he admitted that he had touched her at least 2 or 3 times. So
Yes.
that admission is of at least 3 times.
And was that admission during his interrogation or on the stand?
It was both. So in his interrogation, he said, yes, I had touched her at least 2 or 3 times. And then on cross-examination, the state asked him about that, asked him if he understood the interviewer's questions. And he admitted that, yes, he did understand him and that, yes, he did say that. So that is an admission that he had said it.
And I guess that admission is tied very much to what he said, and I don't see clarity in his interrogation as interpreted at trial of him admitting 3 touchings of her vagina, that there is really quite some ambiguity as to whether he's admitting that for 2 or 3 times. That there was seems like it's pretty clear he admitted a sexual touching on 2 or 3 occasions, but that the specific questions about vagina and penetration, really, he was only speaking clearly about one incident. So I'd ask, can you point me to where in his interrogation it's clear that he was admitting to 2 or 3 touchings of the vagina?
And yes, there was some ambiguity, and that's why that was the defense strategy, to say that he had only admitted the one time. But he didn't do himself any favors when he did get on the stand and he did testify and was cross-examined. And if you could give me just one
Sure.
moment, and I can point you to some record sites to
Thank you.
that. So on record 658, when the defendant was talking about probably most likely the April 16th incident, he did say that he accidentally had sex with his daughter. And then as the state continued to question him about this, he says that, I touched her with it. I touched her, not that I might have put it in, but then he kind of changed that story and agreed that he did put it inside her vagina. That's on page 659. And the state then asked him, if it only happened one time, why did you say that it happened 2 or 3 times? And the defendant answered, I was just really upset. I was very mad. They kept asking me, tell me, tell me, tell me. And so I just said it could have happened 2, 3, 100 times. So there he's admitting that he did do it, but he is trying to walk it back. So it is ambiguous, but the jury hearing that can interpret that as, yes, he is admitting that he had done it more than once, 2 or 3 times, and that is a fair inference from that testimony from him.
Well, isn't that testimony, though, him admitting that he told the police that it could have been 2 or 3 or more times because of the nature of the interrogation? I mean, I suppose there's just multiple ways you could interpret it, right?
Yes, and that's how the defense, both at trial and here on appeal, is interpreting that. But a fair interpretation that the jury could have understood was that, yes, he is admitting that this happened at least 2 or 3 times. And we do view the evidence in the light most favorable to the jury verdict. And we must consider that that is what the jury understood that testimony to be.
Given the ambiguities, there are some areas that I'm more concerned about in terms of the prosecutor's statements in closing argument. And one is about her feeling wetness. And I forget the exact terminology, but indicating she's, as she has in the past, kind of sentiment. That seems to be a misstatement of any evidence that I've found, other than perhaps the one statement that he did the same thing.
Right.
Can you point to anything other than that statement, he did the same thing, that suggests that she felt wetness on any occasion other than April 16th?
Yeah, I think that is probably the most of the testimony from the victim, saying that, he had done the same thing. That can be a fair inference from what the victim did testify. However, it's important to note that this is framed as an ineffective assistance of counsel claim. And so the question is not whether the prosecutor said something incorrect or that it was prosecutorial misconduct. The question is, was defense counsel, was his only option to do in that situation to object? And it was not his only option. Reasonable counsel could have decided that he can address that in closing argument, as he did, and that objecting could have either highlighted that, it could have risked annoying the jury.
Did he specifically address in his closing that there wasn't evidence of wetness on more than one occasion?
What counsel specifically said was that I don't agree with how the state represented that the evidence was. You
That
are
was
the
my
arbiters
recollection.
of the fact, and you need to decide what really happened. And then he went on to say that Alice was lying about the allegations, well, at least 2, because he did admit to 1, and gave a reason why she would have lied to those. So in that context, it really doesn't perhaps matter as much, because the defense is that Alice was lying. So whether she said she felt wetness or not, it really doesn't matter to that defense, because The defense is that she was lying. She could have made all sorts of allegations. So the consistency of those 3 incidences that she testified isn't really all that important to that defense.
Another one that I have concerns about is the statement, we could believe Alice's testimony because it tracked with her statements to police, where the jury didn't have in front of it the statements to the police. That does appear to be the prosecutor saying, you can trust me because I've looked at other evidence. And why would that not be something that counsel would object to? I don't see a good reason why not to object to that.
So I think a fair inference from what the prosecutor said at closing was there was testimony from the responding officer who took the report from both Alice and mother, and he testified at trial that they reported to him that Alice was raped. Alice said she was raped by the defendant. So it's a fair inference that that's what the prosecutor was talking about there. But again, framing this as an ineffective assistance of counsel, what could have counsel reasonably thought at the moment? One is that this could be a fair inference, and that if he does make an objection, he risks being overruled in front of the jury, and that's going to make him look bad. Again, he could just respond to it in closing argument. He could just ignore it. It was a fleeting reference and hope that the jury didn't notice. He doesn't want to risk highlighting that for the jury. So those are many reasons why reasonable counsel might decide not to object in the moment.
Another one that I think is a stronger argument is the suggestion that Alice testified that she was awake and that her mind just shut off. And I think it's hard to read her testimony as her definitively saying or even really an inference that she was awake. She repeatedly testified that she woke up to discover some things and that she was asleep but woke up and discovered things. How is that a fair inference?
Well, I think if I could just read some of her testimony to you. So on direct examination, she testified that defendant, quote, put his penis inside of me and I was just sleeping and I was like so scared. And I woke up and my panties were like down to my knees and he just pretend like he's asleep. She goes on throughout both cross-examination and on redirect. On cross-examination, she said she was asleep, but, quote, I can feel like it's someone doing something. Then I wake up. He's behind me. He is pretending that he is asleep. She also testified on cross-examination that her body hurt. Then on redirect, she said, my body hurt. That's when I wake up. He was in my bed, laying there. And then she said her vagina hurt in the same way on the 13th as it did on the 6th. And on the 6th, she testified about being awake and he had forcibly raped her on that day. So I think a fair inference from that was that she was awake when this happened. And even if she didn't, the evidence was that she woke up, her panties were down below, that her father was in her bed behind her, pretending that he did something. She felt pain. She felt pain in her vagina. And this pain was the same pain that she had felt when she had been raped by her father before. In context, all of that shows a pattern of the defendant coming into her room when she's asleep and raping her, and her waking up to her father doing that. I think in the context of all the evidence that's heard at trial, that is a fair inference that she woke up while he was raping her. And even if she hadn't, there's still a fair inference from that testimony that he had raped her and she had woken up after.
I'm not sure. Can we talk a little bit about the DNA, a little more about the DNA report? And I guess the answer at least from the state's perspective, is that there is no prejudice. I mean, it seems fairly deficient of defense counsel at trial not to at least understand, talk to an expert or get the underlying data to understand what the results of the DNA swabs actually meant, and to object to what maybe have been construed as a misstatement by the prosecutor that the DNA was found on the sperm portion indicated that there was sperm there. It's not enough generally for a trial counsel to not consult with an expert, right? Like, per se, that's not per se deficient performance, correct?
Correct.
And it does seem fairly prejudicial, though, at least that there was, if you're talking about the evidence being the wetness on April 16th and April 13th, I don't know what I'm asking. I guess it feels prejudicial. Why is it not prejudicial to this defendant at this trial? Is it because of his own admission of the evidence?
Yes, because whether this was actually sperm or just his DNA doesn't matter. And defense counsel, when we're looking at deficiency, could decide it's not worth going through, a battle of the experts or reinforcing all of this DNA testimony in front of a jury when my client has already admitted that he penetrated her on this specific occasion. And for those reasons, it's also not prejudicial because that was the defense theory. And getting to that this was sperm doesn't really matter in the grand scheme of things. And even now on appeal, defendant does not contest that his DNA was found on his 13-year-old daughter's inner thigh and buttocks, a place where his DNA had no reason to be. So the fact that it may have been sperm or not really doesn't matter, but it is also a fair inference from the evidence that it was his sperm. Alice testified that she felt wetness after this attack, and also the nurse examiner testified that the vagina is what she termed a natural cleansing environment. She explained that it has secretions that flushes substances that go in the vagina out, and that's on record page 538. And so she further testified that when she swabbed for DNA, she swabbed in the places where that DNA would specifically be, being her inner thighs or her buttocks if her vagina had flushed the semen out. So a fair inference from all of that testimony, her feeling wet, the defendant penetrating her, the swabbing of DNA where semen would likely to be found, is absolutely a fair inference from that evidence that it was semen. So that's a fair inference that the prosecutor could make. That's a fair inference that the jury could believe.
On the question of prejudice, as to the April 16th incident, it does seem like there is compelling evidence that penis to vagina contact happened based on his admissions, and that really the issue that hasn't been admitted to is whether it was intentional. What would you point us to in terms of prejudice on the in the mens rea element there? And
Well, I think just the defendant's own statements where initially he says this was an accident, I thought it was my wife, but then he kind of walks that back. But secondly is the victim's testimony, and the victim's testimony alone is sufficient to support a jury verdict. So her testimony that her father coming into her room and raping her on those 3 occasions, including the April 16th, is enough. We also have testimony from the nurse examiner that there is a penetrative recent injury to her vaginal opening is more than enough. And we also have that his DNA was found there as well.
Thank you.
Not on her vagina, but on
Her inner
in the
thigh and
inner thigh.
buttocks swab, yes.
Any further questions? All right, I've not seen any further questions for the state. Thank you.
The state would ask to affirm. Thank you.
All right, Mr. Trumbo, you have your rebuttal.
Your Honors, I think you will find throughout the defendant's direct and cross-examination and redirect testimony that he did say he was confused at times during the interrogation, that he didn't understand exactly what was being got at, and he did clearly deny any penetration except for the one time, and that it was an accident. But I will point out, this may or may not really ultimately come into the analysis for the court, but even if the court were to conclude that there were clear admissions of 2 or 3 penetrations, there's still the jury unanimity issue that we brief, where if they had evidence from the examiner of a year's worth of reoccurring abuse. The jury had heard that, but the state was only charging 3 specific instances at the very last month in April of 2019. And so even if you were to take that testimony, which we strongly contest is there, certainly not clearly there, the jury would still have to be unanimous as to that the 2 or 3 instances that were admitted to are the same 2 or 3 instances that are alleged in the information. So we don't have a situation where there can't be prejudice. In terms of fair inference on sperm, I think I'll just say the evidence in the examination is that there was no male DNA in the vaginal swab, any of the swabs other than thigh buttocks. And if there's touching of thigh buttocks, that is not rape of a child. And furthermore, there's just there's no fair inference of finding of a sperm fraction, which is what he testified to. Your Honors, I'll end with just making the point that this was not an easy case for the state to prove. They had a case where even for April 16th, very different stories. He was admitting to him sleeping and the daughter coming in and without her clothes into his bed. She testified to being in her locked room and waking up to her father with his jeans on and concluding that something had happened to her, which she did not give the level of detail that would, in our view, show rape of a child. Your Honors, for the reasons in our briefing, we asked the court to vacate and to remand.
All right, thank you, counsel. We appreciate your briefing in this matter as well as your argument this morning and indulging our many questions. We will take this matter under advisement and issue a decision as soon as we are able to. And with that, we'll be in recess.